Good evening, everyone. Advocate on Record Aspirants Academy, popularly known as AAA, welcomes you wholeheartedly and wish you a very happy new year. And this new year will bring us new hope and new life, new feather to our cap. Before going to the topic, it is always told that the most important aspect is knowing oneself. We say Lord Buddha and many other enlightened souls, like they are all enlightened souls. We as a common man, we do not understand the term enlightenment. Because we become an AOR, we can guide others to become an AOR. Only the enlightened soul can guide others to become enlightened. So, because Lord Buddha sat under beneath the tree of people tree and he became enlightened and he knew himself, he knew the truth. But how to understand, how to make understand the layman, what is the enlightenment? The question was put to Lord Bodhidharma, because everybody says enlightenment, what is the meaning of enlightenment? He said enlightenment means, he put it in three terms, like 3 bullet points to the common man, layman in the world of the spiritual world. Firstly, you must always be active, enthusiastic in whatever you do. For example, if you are the listener in a lecture, you have to be the keen listener. If you are delivering a speech, it must be an effective speech. So therefore, always be active. If number 2, always do the hard work. Hard work is most important, because we ourselves, the peers, the lawyers, they reach court at 10 o'clock, they leave to their office by 4, they also draft the petitions, they also argue their case. How to make an advocate from an extraordinary advocate? How to, if the law students are here, how to become an extraordinary law students? The answer is very simple, dear friends. Give extra effort to become extraordinary advocate. That is most important. We should not only do the work, we should do the best. We should give the best. That is what Bodhidharma has said. Always be hardworking. And third is most important. Always be active, always be hardworking, and have the quality of perseverance. Because our efforts may fail, but we should not fail to make efforts. That is why Abraham Lincoln, former president of USA, though he has lost in elections almost 10 to 11 times, and finally he won in the election for the president. When he was interviewed, what is the definition of success? He said, the definition of success according to Abraham Lincoln was moving from one failure to another failure. It is moving from one failure to another failure without losing enthusiasm. He is not saying that moving from one success to another success. Moving from one failure to another failure without losing enthusiasm. That is most important. So the message today is, we should be enthusiastic. Our efforts may fail, but we should not fail to make efforts. So let us keep this one mantra for this year to practice, and then let us see the results. Today we have sown the seed in the minds of our AOR aspirants. Please give an effect to it. With this, let me move on to the lecture. That is, today is our 20th lecture. The topic is overview of special leave petitions. We have delivered few lectures on special leave petitions on various topics like introductory to a special leave petition. Secondly, when the Supreme Court can interfere under various circumstances. Now we are going to cover what is the overview of SLP. Under this topic, we will be covering various topics. What are the frequently asked questions in the question paper? Exams are going to come, say in the month of June. We may think that it will be coming only after 6 months, but it will just go like 6 days. Therefore, let us do the work from today onwards. We are there with you, we are there to guide you. And then let us start the preparation. Therefore, it will not be a burden for us. The journey will be very smooth. So, the topic for today, Article 136. Before going to the topic, it is our regular practice to recite the preamble of the Constitution of India. Because according to us, preamble our goal and preamble our soul. So I request each one of you to recite preamble along with me. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now, moving on to Article 136. Before going to the topic, let us understand what is Article 136. Majority of the cases filed in the Honorable Supreme Court through invoking Article 136 by filing special leave petitions. What is Article 136? What does it say? Notwithstanding anything contained in this chapter, that is how it starts. Notwithstanding anything contained in this chapter means chapter 4, the Union Judiciary. The Supreme Court may, it is not shall, dear friends. Each word has to be understood correctly. The Supreme Court may, in its discretion, grant leave to appeal against judgment, degree, determination, sentence, or order passed in any cause or matter made by any court or tribunal. They are saying any court or tribunal in the territory of India. The words are very, very wide. Therefore, plenary, inherent jurisdictions, they have given enormous power to the Honorable Supreme Court. You can prefer an appeal under 136 even if it is an order passed by any district courts also. Even it may not be a final order also. It may be an interim order or passed by any tribunal. But only thing is, you need to establish before the Honorable Court why you have not exhausted your remedy before the Honorable High Court. If you are appealing directly to Supreme Court from District Court. That is clause 1. Clause 2 says is an exception to clause 1. Because they are saying this clause 1 will not be applicable for the orders or judgment, determination, sentence passed by any armed tribunals related to the armed forces. So that is the exception, dear friends. And we have discussed this power is enormous and the sky is their power. There is no limit to the sky. There is no limit to the power of the Honorable Supreme Court. In one interesting court proceedings where I have personally witnessed, Honorable Justice Rohinton Nariman, my Lord, observed that though you have challenged the Honorable High Court order before the Supreme Court under Article 136, though we find it is a wrong judgment passed by the Honorable High Court, but in these facts and circumstances of the case, we will not exercise our discretionary power under 136. Therefore, we are not interfering. So I was shocked to know, though they find it that there is a erroneous order, but in the facts and circumstances, the lordships are not exercising their discretionary power. Secondly, very recently, we have dealt with one of the cases assigned by Supreme Court Legal Services Committee, where the wife filed a transfer petition before the Honorable Supreme Court, seeking transfer from state of UP to Karkoduma Court, Delhi. But the Honorable Supreme Court has found, though our prayer in transfer petition is seeking a transfer of the divorce petition filed by the husband in Kairana, Shamli, state of UP to Karkoduma. That was our prayer. But interestingly, both husband and wife, they work in Muradabad. The court asked us a very pertinent question. Why do you want to get it transferred to Karkoduma? I placed the facts that domestic violence case, 498 cases are pending before Karkoduma court. But the interesting fact is both of them are working in same place, that is Moradabad. Therefore, the Honorable Supreme Court invoked Article 142 by saying that in the interest of justice, that the matter need not be transferred to Karkoduma, we will transfer it from Shamli to Moradabad court. So generally the settled principle of law is the relief has to be granted whatever we have sought. It was not our prayer, but the Honorable Supreme Court has exercised Article 142 to go beyond our prayer in the interest of justice. They have transferred it to a particular place, that is Moradabad, where our prayer is not that. So therefore, dear friends, my humble request is to understand the power of the Honorable Supreme Court. The basic structure is very important, and we do not know what is basic structure even today. It is very exhaustive, and it depends upon the facts and circumstances of each case. The list will get added on. So therefore, the Supreme Court is the enormous power it has. So as an advocate on record, we are going to assist the Honorable Supreme Court to uphold justice. Therefore, our responsibility are so much. So therefore, we need to realize our responsibility, and we have to strive towards excellence. And today's topic, I have framed two questions, dear friends. Due to paucity of time, there is a farewell function also for Honorable Justice C.T. Ravikumar Justice. So therefore, I will be covering only two issues today. And first and foremost is, under what circumstances, the first question, I will be giving the answer also. Under what circumstances the Honorable Supreme Court can revoke the special leave granted earlier? I repeat, under what circumstances the Honorable Supreme Court can revoke the special leave granted earlier by the Supreme Court?
Specially granted, next point.
Under what circumstances the Honorable Supreme Court can revoke the special leave granted earlier by the Honorable Supreme Court? So let me give an illustration, dear friends. It is not a matter of right that we prefer an appeal under Article 136. It is a matter of discretion vested with the Honorable Supreme Court. So it is always our prayer in the special leave petition is Please be grant leave to appeal against, grant special leave to appeal against the order passed by the High Court, order dated so and so. So once we prima facie establish that we have a case and the Honorable High Court has gone wrong by giving a finding, so based on our arguments, based on our grounds urged in the special leave petition, the Honorable Supreme Court will grant leave granted. That means leave granted in the sense that Honorable Supreme Court is fully satisfied that you can challenge the High Court order. Leave granted. Thereafter, when the respondent comes to the Honorable Supreme Court and says that in this case there are some suppression of material facts by the petitioner, he has given an untrue statement, false statement, inaccurate statement in the special leave petition. So what is the effect of it? The effect is the leave granted by the Honorable Supreme Court can be revoked, can be officially cancelled, and they can impose cost also. They can dismiss the special leave petition also. So the principle is, whenever you approach the court, you must approach the court with clean hands. What does it mean? It means a complete disclosure of facts. There should not be any suppression of material facts. And you should not utter falsehood on oath before the court, be it any court. I am talking about not only Supreme Court, High Court or District Court or any tribunal. One who seeks justice should always come with clean hands. The principle is this. Otherwise, if a litigant takes the shelter of falsehood and he gives false statement before the court, or he deliberately suppresses the material fact, inaccurate statements, then what is the effect? The effect is those petitions should be nipped in the bud. And there are certain judgments passed by the Honorable Supreme Court held that when a person does not approach the court with clean hands, then his case should not be decided on merits. Number one. Number two, that person should not be entitled to any relief, be it interim or final. And they can issue contempt also. Contempt proceedings can be initiated against a person who takes the shelter of falsehood. And moreover, perjury proceedings, previously under section 340 CRPC, Criminal Procedure Code, where a complaint will be made by the presiding officer to the magistrate to take cognizance of the falsehood uttered in the court. So therefore, dear friends, we must be very, very careful while drafting our special leave petitions. The synopsis, grounds, facts, everything has to be verified by us. So everything the Honorable Court will accept only when there is written paper, right? When he says that it has happened, ask for the document. Unless and until it is not supported by any documents, don't take that plea. Otherwise, the leave will be revoked. In this case, what happened? Let me refer this case, dear friends. The interesting case, Hari Narayan versus Batri Das. I repeat, Hari Narayan, Narain versus Batri Das, Badri, Batri Das, Das. It is reported in 1964, volume 2, SCR, Supreme Court Report, page number 203. I repeat, 1964, volume 2, SCR, page number 203. This judgment was a combination of three honorable judges. Honorable Justice P.B. Gajendra Katkar, Honorable Justice M. Hidayatullah, Honorable Justice J.C. Shaw. First, let me tell you, dear friends, before reading the relevant portions, let me tell you the facts of the case. Here the landlord Batri Das, landlord has filed a suit for what? For ejectment of the tenant. He doesn't want the tenant to continue in his possession, therefore he filed a suit. Why? Because he failed to pay the rent. He defaulted in making rent. So he filed a suit for ejectment. Suit was dismissed by the trial court, meaning thereby landlord has lost and tenant continued to be in possession. Now landlord is aggrieved. He prefers an appeal to the additional sessions judge Jaipur. He prefers an appeal. Appeal was decided in favor of the landlord. That means tenant has to be evicted from the premises. Now tenant is aggrieved. He went to the High Court. High Court also upheld the order of the First Appellate Court. Now again tenant is aggrieved. He comes before the Supreme Court by way of special leave petition. He asked for a certificate, that please grant a certificate. He made a request to the Honorable Court, High Court, to grant a certificate that it is a fit case to be decided by the Supreme Court. But the Honorable High Court did not grant any certificate. Therefore, he preferred special leave petition under Article 136. So, based on his submissions, tenant submissions, the Honorable Supreme Court has granted leave also. Right? So, leave granted. Now, the respondent makes a petition before the Honorable Supreme Court that he has suppressed certain material facts. Therefore, leave has to be revoked and his petition should be dismissed. So, what happened in this case? What was that material suppression of the fact and why it landed up in the dismissal? Let us see, dear friends. The landlord filed a suit for the ejectment of the appellant, that is the tenant. The suit was dismissed by the trial court. The respondent filed an appeal in the court of the additional sessions judge, Jaipur City. The appeal was accepted and the claim of respondent for ejectment was allowed. So it went in favor of the landlord. The appellant, that is the tenant, filed an appeal in the Rajasthan High Court, but that was also dismissed. The High Court also refused to grant a certificate of fitness to appeal to this court. The appellant filed a petition for special leave to appeal to this court and the same was allowed. The respondent filed a petition in this court with a prayer that special leave granted to the appellant be revoked on the ground that the appellant had made inaccurate, untrue and misleading statements in the petition for special leave. This court also found that the appellant had made certain wholly untrue statements in the petition for special leave. What is that? The statement that he has made? In the special leave petition, he has said the appellant has taken 6 grounds, the tenant has taken 6 grounds of appeal against the decision of the High Court. The last ground is that respondent had claimed eviction in the trial court on the basis of alleged non-payment or non-tender of payment of rent from December 2nd, 1958. He says, the tenant makes a submission to the Honorable Supreme Court by saying, according to the landlord, the tenant makes a submission, according to the landlord, that I have defaulted in making rent only from 2nd of December 1958, but the First Appellate Court and the High Court has put up a new case for landlord by saying that I have defaulted, the tenant has defaulted even prior to, even earlier to December 2nd of 1958. So, but the first appellate court and the High Court set up a new case for the landlord by taking into consideration the alleged defaults prior to December 2nd, 1958 and not relied upon by the landlord himself. According to the landlord himself, that he claims only there is a default from 2nd of December, whereas the first appellate court and the High Court has said that tenant has committed default even prior to 2nd of December. Therefore, they have put up a new case for the landlord. So, this was his submission or the grounds made in the special leave petition. Now, the respondent comes into the picture. Notice issued, leave granted, he comes into the picture and he says, see, I have already stated in my plaint itself that he has already committed default. So, he has made a wrong statement before this honorable court. But though he has committed default, but he has made a payment by way of a check on 2nd of December 1958, doesn't mean that he has not defaulted earlier. So, that was his submission, the respondent's submission. The respondent contends that this is a complete misstatement of the true position, and in support of his argument, he has referred us to paragraph 3 in the plaint. It appears that the rent due from the appellant for the period from 1st of November 1957 to November 30, 1958, which had fallen in default, was deposited by him, that is the tenant, by check on December 2nd, 1958. Paragraph 3 of the plaint specifically refers to these defaults and in fact takes into account the said defaults for the purpose of setting up the respondent's case that the appellant had committed more than 3 defaults in the payment of rent of 2 months each during the period of 18 months. Therefore, there is no doubt that the unambiguous and categorical statement made in the last ground of the appellant's petition for special leave is wholly untrue. So, this was one of the submissions made by the respondent, and similarly, the respondent has brought one more incorrect statement made by the appellant petitioner. But ultimately, the Honorable Supreme Court has said this. But who has appeared for the tenant? Very interesting, dear friends. MC Setalwath. He has appeared, the first Attorney General, in whose name the chamber is there, opposite to Supreme Court, gate number D, MC Setalwath block. He has appeared on behalf of the tenant. And he has made a submission. I only argued this case even for at the admission stage also when the leave was granted. So, what was his submissions? On the other hand, Mr. Setalwath contended that he had appeared at the time when special leave was granted, and to the best of his recollection, he had not referred to these grounds, but had merely urged his contention that the High Court has misconstrued under section 13 clause subsection 1A of the Act. So, what was the submission made by Mr. Setalwath? Though he was appearing on behalf of the tenant, he said at the time of arguing the case, I never referred to these incorrect grounds. I confined myself only to the interpretation of that particular provision. Based on that, leave was granted. Therefore, today leave should not be revoked on the incorrect statements. So, this was the submissions made by Mr. Setalwath, senior advocate. Now, the honorable judges are saying that we have no hesitation in accepting Mr. Setalwath's statement, but in our opinion, in dealing with the respondent's prayer, that special leave granted to the appellant should be revoked. What was actually urged before the court cannot be decisive of the matter and may not even be material. It is true that in the present case, special leave was granted on September 26, 1962, and it is possible for Mr. Setalwath to recall what he argued before the court when special leave was granted. But it is necessary to bear in mind that the appeal may come on for hearing long after special leave is granted. For example, leave granted today, It may come after 4 years. It may come after 2 years. So, it is necessary to bear in mind that the appeal may come on for hearing long after special leave is granted. That counsel appearing at the stage of admission may not be same as at the stage of final hearing. So today an advocate will be engaged to argue the case at the admission stage, but at the time of final hearing, maybe after 4 years, 5 years, we do not know whether the same counsel is retained, same advocate on record is retained by the client or not. Even judges who issues the notice or who grants leave will not be hearing the final stage. Final hearing cannot be heard by the same judge. Might be they must have retired also, because it comes out of several years. That is what they are giving the opinion. Therefore, it is no answer to the respondent's contention that though the material statements in the special leave petition may be substantially inaccurate, though not wholly untrue, those statements may not have influenced the court in granting special leave. Mr. Setalwat has also invited our attention to the fact that the impugned statements and grounds are substantially copied from the averments made in the appeal before the High Court. So, whatever the grounds that we made in the special leave petition is nothing but the replica of the appeal which we filed before the High Court. Therefore, what we have made the statement before the High Court, same is copied here also. That may be so, but the fact still remains. Fact still remains that two important statements which, if true, may have been of considerable assistance to the appellant in invoking the protection of section 13 subsection 1a, even on the construction placed by the High Court on that section, are found to be untrue. And that, in our opinion, this is very important, dear friends. For this purpose only, I have cited this case. In our opinion, is a very serious infirmity in the petition itself. It is of utmost importance that in making material statements and setting forth grounds in application for special leave, care must be taken not to make any statements which are inaccurate, untrue, or misleading. So we have to be very careful while drafting a special leave petition, and we have to see to that there is no untrue statements or misleading statements or incorrect statements. In dealing with applications for special leave, the court naturally takes statement of fact and grounds of fact contained in the petitions at their face value, because the Honorable Supreme Court considers the grounds, consider the synopsis what we write, and takes it at their face value and issues notice. So in dealing with the applications for special leave, the court naturally takes statements of fact and grounds of fact contained in the petitions at their face value, and it would be unfair. See the term that they have used. It would be unfair to betray the confidence of the court by making statements which are untrue and misleading. That is why we have come to the conclusion that in the present case, special leave granted to the appellant ought to be revoked. Accordingly, special leave is revoked and the appeal is dismissed. The appellant will pay the cost of the respondent, meaning thereby tenant has to pay the cost to the respondent, that is the landlord. Now he makes a humble submission, Mr. Setalwat. Mr. Setalwat requested us to give the appellant, that is tenant, to vacate the premises. Give us some more time to vacate the premises. He invited our attention to the fact that the tenant has invested large amount in setting up machinery of the oil mill, which he is running in the premises in question. Mr. Anley, that is who is advocate for the respondent, Mr. Anley for the respondent has fairly conceded that on condition that the appellant unconditionally undertakes to deliver possession of the premises to the respondent within 6 months from the date of this judgment, he would not execute the decree for ejectment. Mr. Setalwat offered an unconditional undertaking on behalf of the tenant as suggested by Mr. Anley. We, that is the Honorable Supreme Court, accordingly direct that on the appellant's undertaking, that is tenant's undertaking, the landlord should not execute the decree for 6 months from today. And finally, dear friends, this is very important: special leave revoked, cancelled, appeal dismissed. So therefore, dear friends, this is very, very important, and this is my personal opinion, dear friends. This is most important. The reason for judicial delay. The reason for judicial delay is more number of cases filed. But how many cases are genuine? How many cases are filed in order to take revenge, in order to harass the other side by uttering falsehood after falsehood on oath, with no fear for the respect for law, no fear of accountability, no fear of penal consequences? If you have a system to filter it, at least prima facie, whether is this a fit case, whether is this a fit case to reach the honorable court's table, if we look into it, and if there are falsehood uttered, then if you are going to prosecute them for falsehood, number two, if you are going to take any disciplinary actions, disciplinary proceedings against such persons, if they are working in the employment, therefore falsehood may affect their livelihood. So they will have the fear and they will approach the honorable court with some sort of responsibility, with full complete disclosure of true facts. Otherwise, anybody may file any false case today. To say that it is false, it takes 5 years, it takes 10 years. So who will pay the damages for those 10 years? Unnecessarily harassed. He has to be there in court personally or through a counsel. So this system has to be changed, dear friends, and it can be changed only through the indominant. We have to change it through the great willpower jointly, and we should work for the system. That is most important. With this, I thank you very much, dear friends, for your patience hearing. So wish you all the best. Thank you.